Welcome, my name's Alex Ground. I head up the planning team here at Russell-Cooke, and this is a short webinar on Section 73 applications and permissions. The three things that I'm going to talk through are, first of all, what are Section 73 applications? A bit of background to a key case in this area, the Finney case. Secondly, I'm going to look at the Finney case itself and what that held, and the implications for how to achieve changes to planning permissions going forwards. And thirdly, looking at the case of Lambeth, and in light of that case, how should one now go about interpreting Section 73 permissions that have been granted? So firstly, what are Section 73 applications? They are applications to develop land without compliance with conditions. They're commonly referred to amendment applications, but that's a little bit of a misnomer because actually they result in a whole new planning permission, so that you have the original planning permission and your new Section 73 permission sitting alongside it, and the developer will always have the opportunity to choose which one to develop. Of course, they'll usually be going for the one that's amended, hence they went for the amendments in the first place, but don't always make that assumption. The ability to make these applications was brought in to provide the appellant with an alternative to appealing against the original permission as a way of achieving changes. When the local authority come to consider a Section 73, they should only consider the question of the conditions. However, it does result, as I said, in a new planning permission, and therefore it must also be determined according to the development plan in place at the time of the Section 73 determination and any of the material considerations in play at that time. So this is a key phrase from the key decisions: considering only the conditions subject to which planning permission should be granted will be a more limited exercise than the consideration of a normal application for planning permission, but how much more limited will depend on the nature of the condition itself. I thought it'd be useful to illustrate how authorities should go about it and how not to go about it, by the case of Stefano. So this involved a planning permission which was granted for changes to a facade of a building and a 3-storey basement. After that was granted, changes wanted to be made to the scheme, and the local authority made it very clear in correspondence that they were only looking at the changes opposed to the whole of the scheme. Permission was granted, that was successfully challenged. In the decision of the case, why it was successfully challenged, Judge pointed out that what they should have done, the local authority, they should have looked at the development plan in place at the time of the Section 73. What was key here was that there had been changes to policy on basements in between the original permission and Section 73, such that it was much more prohibitive as regards basements by the time of the Section 73. Local authority hadn't done that, and therefore it was right that it was an unlawful decision and had to be quashed. Of course, what the local authority could have done was they still could have taken the fallback planning permission as a material consideration, and they could have come to the view that that outweighed the current planning policy on basements and come to the same decision, but it certainly wasn't inevitable that they would have come to the decision if they'd done that, hence it had to be quashed. So the big question that was put before the court in this case of Finney is, can you use Section 73 to grant a new planning permission with revised conditions where the effect of the revised conditions would be to contradict or change the operative part of the original planning permission? Just before we dive into the case itself, I thought it would be helpful to give a brief background. So the position pre-Finney was as set out in the Arrowcroft case, and this had decided that you can impose different conditions if they don't result in a fundamental alteration to the proposal originally put forward. In that case, it was decided that changes were fundamental. The original planning permission was for one large store, but changes to conditions would have allowed 6 smaller units, and say that was held to be a fundamental change. So the case of Finney itself, in the description of development, it described the turbine as being up to 100 metres. There was a condition attached to that permission which required the 2 wind turbines to be in accordance with plans. One of those plans showed the turbine to be 100 metres tall. A Section 73 application was then made, trying to make it 125 metres tall. History of the application was that the local authority refused it. Section 73, refused Section 73. It was then appealed, and the inspector granted it. Mr. Finney then challenged that inspector's decision. In the course of their judgment, it was made a reminder, really, that the only, on a Section 73, the only 2 things that a local authority can do are choose between 2 options. One is granting the same permission subject to different conditions, or refusing the permission. Section 73 itself, it was held, had no power to grant a new planning permission with a different operative part from that contained in the original. So you have the description of development and the conditions, and say you just, it was held that you just cannot change description of development part. The key finding, however, was that it would also be unlawful for local planning authority to impose a new or amended condition on a planning permission under Section 73, which was inconsistent with the operative part of that permission. Following submissions as to what are developers supposed to do now when they're meant to make changes, the judge had set out that the options are that you can use what's known as a non-material amendment, Section 96A application, or indeed just reapply for a new permission. But obviously applying for a whole new permission can have lots of unintended consequences as regards, for example, community infrastructure levy changes, as well as time and cost delays in going down that route. So just thinking post this case about the 2 different times at which one can influence trying to change a permission. One is obviously predetermination of the application, and then secondly, if you want to make changes after that permission has been granted. So before your scheme gets granted, the most important thing always now to think about is trying to achieve a wide description as possible, and perhaps proposing conditions to narrow it down. In our experience, authorities are dealing with this varied manner. Some authorities are pushing back, but often in our experience, if we engage with them and explain that they still have the ability to control what is in there through conditions, often they are accepting that. Local authorities do have the power to amend the description of development. Often they need to reconsult, depending on what stage it's got to. And the MPPG does confirm that. They say they do have that power, but it does make it clear that if they are going to make changes, they do need to discuss with you as applicant first before just imposing any change description. So it's really worth spending time at that point, trying to get the local authority comfortable with something, and opposed to just accepting a lot more detail in that description of development, because that really could tie you down later on. So if you end up with a planning permission that after that you do need to make changes to it, such that the description of development needs to be changed, so Section 73 is no longer going to be an option open to you in light of the Finney case, first of all, you should consider trying to use Section 96A. Can what you're trying to do fit in to being described as a non-material amendment? What is and isn't a non-material amendment isn't set out in statute. There's simply guidance about what it is in the context of a scheme. The local authority have got to have regard to the effect of the change and any previous changes under 96A. Really important point to note is that the 96A power can be used to impose new conditions or remove or alter previous ones. Unfortunately, you can't appeal a 96A decision. So if it is refused, you don't have that option. You only have the option to judicially review it. Another important point to make is that amending the existing planning permission by 96A results in amending your original permission opposed to resulting in a new planning permission. Now you'll recall that that's different from the use of the Section 73. So what a lot of cases have done is use 96A to remove some of the description of development. So in this case, they remove the reference to numbers of seats in a stadium, the description of development, and then use Section 73 to vary those plans. Post this case of Finney, and it is now settled law, as recently only as last week, the Supreme Court have refused permission for the Finney case to be appealed up to the Supreme Court. So Court of Appeal has had the final say on the matter. We understand that some local authorities are in fact lobbying government to make a change in the law in statute to go back to the position pre-Finney. So you'll remember the pre-Finney position was that provided it wasn't a fundamental change that you were trying to do, you could use Section 73. So we'll have to see how that pans out. One important point to note is that even as the position is at the moment, Finney doesn't prevent material changes in conditions. It simply prevents those where they're going to result in a conflict with the description of development. One other thought that we've had and been discussing with our clients is if 96A can't be used, whether Section 97, the Town and Country Planning Act, can be used. These are modification orders. Local authority, they give power for the local authority to revoke or modify any planning permission and can be used at any time until the development has taken place. Compensation would usually be payable, but in this circumstances, using it in, that could be formally be waived. We've not had a situation yet where we've had to actually try and use it, but I do think the power potentially could be used. And it is worth considering if you can't get there by using a 96A and Section 73. So just a quick example of how this pans out in practice. So take a planning permission for 8 units. Description of development also says it's for a certain specified number of detached and semi-detached units. After grant of that permission, you want to change it so that the mix of detached and semi-detached changes. How do you go about that? The way that you go about it now is by using a 96A application to change your description of development. So you remove that detail of the split between detached and semi-detached, move that into a condition if necessary, then use the Section 73 to change your plans listed. Recent appeal decision just reconfirms this position now that where you're changing a condition that then will conflict, that is no longer lawful, and so that is now filtered down and very, very clearly the inspectorate are carrying that out. So Section 73 just can't be used where you'll end up with a conflict with your description of development with new plans. So just thinking a little bit more widely about what some of the implications might be of this Finney case, in particular for land promoters. Do they need to consider whether permission that they're getting will still be attractive to developers who they'll sell to? So previously it would have been very common for developers in that scenario to go back in and obtain changes to the scheme. So it's just an important reminder, I think, that those land promoters should be trying to talk to their ultimate buyers, the people who are going to develop out the scheme, perhaps sooner than they would otherwise have done, to try and ensure that they get a scheme that is capable of being built out, meets their requirements, to try and minimise the prospect of having to go back in for a full new planning application. Then finally, on to the case of Lambeth. This was all about a planning permission, original planning permission that had been granted for retail, subject to a condition excluding food sales. Section 73 was granted. It failed to reimpose the equivalent condition, albeit, probably very importantly, had a description of development referred to the sale of non-food goods only. This went all the way up through the courts, and the Supreme Court held that the condition from the original permission was still effective. So this has got profound implications for all of those of us who have to advise on planning permissions, section 73s, and what is and isn't a relevant condition anymore. So you now have to take extreme care in interpreting your section 73s. You need to review and reference your original planning permission and all other intervening section 73 permissions to try and establish what conditions might still apply, whereas previously you only had to look at your most recent section 73. It's quite an unhelpful decision, as you say, you now need to look at the intent of the applicant and extrinsic evidence to try and work out if all of those conditions come across. So far clearer position than it had been prior to this case. Finally, the construction of section 106 agreements, this case in Norfolk Homes, this involved a section 106 agreement, and in it, it didn't say, as is often common in 106 agreements, that it also bound any future section 73s. So the question was, after a section 73 had been granted, did the developer take free effectively of all the obligations? And the initial court decision is that it doesn't. So that's the end of the webinar today. If you've got any questions, I'd love to hear from you either by email or telephone. So please do get in touch, and I hope that's been helpful. Thank you.